So, let's first the notice, then a fixed day for motion. Then, in order that such a resolution, so let's first of all, notice of resolution, then admissibility of resolution. That's the third stage. In order that such a resolution may be admissible, it shall satisfy the following conditions. Namely, it shall be specific with respect to charges, because removal involves a stigma. That is, Constitution uses the word removal, not a no confidence. But as your Lordship knows, in a no confidence motion, you don't have to give a reason. Well, the House votes and you are out. But in the case of a removal, you have to give reasons. You don't say nabam rebia. In fact, this petition could never have been filed against Malats on 27th, on 26th for an order on 27th. This is no notice in the eye of law. But that's on merits. I'm not going to go into that. Then it shall be clearly and precisely expressed. And it shall not contain arguments, inferences, ironical expressions, imputations, or defamatory statements. Then 201. Subject to the provisions of 96 of the Constitution, the Speaker or Deputy Speaker or such other person, as is referred to in Clause 2, shall preside when a motion under Sub-Rule 2 of 200 is taken up for consideration. The member in whose name the motion stands in the list of business shall, unless makes a statement conveying unwillingness to move the motion. So, this is the point I was making. Even when the motion is in the House, he may not be willing to move it. So there can be no injunction for him to continue with the 10th schedule and the proceedings. Because the resolution, let me tell you, I have some experience in Parliament, let me tell you what happens. What happens is that whenever a resolution...
But according to you, there can't be any injunction at all, irrespective of the stage of the motion. Right?
Yes, because that is to him. This third, 10th schedule,
even if it is admitted, there is no bar on
No.
Even during the 7 days.
Yes. I tell you, Lordship, why? The 10th schedule deals with strangers. The motion deals with him. The 10th schedule deals with third parties. The motion deals with him, so he cannot preside on that particular day when it's under consideration. Well, what has got to do with third parties? Now, these issues were never discussed in Nabam. That's why Mavlankar says that there can be no... There's no specific... that's why Malas is allowed to participate in the proceedings of the House. He's allowed to speak, he's allowed to vote.
Yes, Mr.
Now, Malas, kindly continue to read this, Malas. So, I was reading 2. A member in whose name the motion stands on the list of business shall, unless makes a statement conveying unwillingness to move the motion when called upon to do so, but in either case, no speech shall be permitted. Now, Malas, he continues to preside over the House. The Speaker continues to preside. Then the Speaker or the Deputy Speaker or the person presiding, as the case may be, shall thereupon place the motion before the House and shall request those members who are in favor of leave being granted to rise in their places. Even then he is presiding. Right. Sorry. If not less than 50 members, as I told you, there's 29 there, rise accordingly, the Speaker or the Deputy Speaker or the person presiding, as the case may be, shall declare that leave has been granted and that the resolution will be taken up on such day, not being more than 10 days from the date on which leave is asked for, as the Speaker or the Deputy Speaker or the person presiding, as the case may be, may appoint. If less than 50 members rise, the Speaker or the Deputy Speaker or the person presiding, as the case may be, shall inform that the member has not the leave of the House. On the appointed day, the resolution shall be included in the list of business. Then it becomes under consideration. On the appointed day. That's why I was telling your Lordship my experience in Parliament. What happens is, Mullahs, supposing there's a bill, forget about this removal. There's a bill, Mullahs. What do? We stand up and I say, do I have the leave of the House to introduce the bill? The House is asked for, the leave is granted, I introduce the bill. but it's only introduction. Then, Malas, the matter goes to the Business Advisory Committee. In the Business Advisory Committee, after discussion with everybody as to when you should bring the bill up, Malas, then a date is fixed. Then on that particular day, Malas, some other matter may be going on, Malas, it doesn't come up, it goes on to the next day. Then, Malas, when it comes up on the next day, we rise in our chair and we say that I propose to move the bill for the consideration of the House. That's when it's considered. The same procedure applies. So this whole argument at the time of the problem with Nabam is it says the moment the notice is given, you can't function. That's what Nabam decides for us. Therefore, these rules are all ultra-virus according to Nabam. Because he can't preside. So these are serious issues. And there are live issues, these are not dead issues. Especially in the context of that letter, Malas, notice on 22nd, dated 21st. The idea was not to allow the speaker to function. The whole purpose was that. Now your lordships put to me, but then it's a free, and rightly so, that the speaker has no impediments in his way to decide the matter. But that's what Holohan says. What does 110 of Holohan say? There can be no legitimate action before he decides. That's 5 judges of this court. Therefore, the 27th order could not have been passed. Your lordship put it to me that no, we only adjourned it. In the interim, I adjourn it. I give them time to file a reply. What does in the interim mean? You extend the time, I can't decide. What else is it except stay? What else is it except violation of para 110 of Nabam Rabia? What else is it but it's a quitamate order? Can you put it in any other framework? No, I'm sorry. So Nabam, Holohan says you can't interfere. If you can't interfere, then the speaker has to decide. And the whole problem arose because of the 27th order. That's a live issue. That's not a dead issue. That's not academic. Because it was on 2 grounds. Nabam Rabia and 2 days notice. So if that was bad, everything will go. Because then what it catapulted into a situation where an elected government is toppled. Because of the disqualification of the deputy speaker not being able to decide. So my respectful submission to your lordships is that 179 for removal operates in an entirely different field. Now I must also disclose to your lordships that the Maharashtra rules do not have this what the Lok Sabha rules have.
So what do we, the flip side, Chief Justice,
Yes.
situation where it's not really a case of an anti-defection, it's a case where there's perhaps a realignment, even a starker case than this, where there is actually realignment is going on. And the Chief Minister is in an awful minority. Then knowing the writing on the wall, the Speaker would want to declare all the others who are on the other side as violative of.
He can't unless there is a petition before him.
That's another.
Yeah.
Petition part of it is what you are saying, this application, this notice is actually not equivalent to a petition. We are on the interpretation. We are on the question of should the Speaker restrain or postpone it till some point of time. We are only on that question. In a situation like this, in order to preempt a situation, Speaker takes up the matter and immediately disqualifies them.
Let me answer that. Very important question. Let me answer that. Mulats, let's now bifurcate these two. One, you can't have a notice before a petition for disqualification. That's one part. You can only have a notice after the petition for disqualification.
Okay, that point is taken. Well,
Correct?
go to the
After
next
the
point.
notice.
What's the next
Now,
point?
supposing there's a notice after the petition of disqualification. In that event, everything would have happened already.
Suppose there is a
The
notice.
facts would have happened already, Malas, because the notice will have to be based on
Take a
allegations based.
situation where a notice is there. Take a situation. Assuming for a minute that this 20, instead of 21st, it's a 20th notice. Then what will
Makes no
happen?
difference. Not 20th,
No,
24th.
there is a notice on 10th schedule
Yes.
already given by one of the minority
okay,
members.
okay.
Then what will happen?
I tell you, Lordship, what.
Then the speaker proceeds further to disqualify all of them.
Why not? Because that's the law. That's why I said under the 10th schedule, there is no minority-majority issue. There is only a merger issue.
So therefore,
There is no defense under the 10th
in
schedule.
about 2 days' time, he proceeds to consider the 10th schedule and immediately he passes.
But Malaj, if out of 55 or 58, 40 are on the other side, it's covered by the 10th schedule. Because there's no defense. Malaj, as your Lordship knows, under the 10th schedule, you are given only defenses. If there's a petition for disqualification, there is only a defense available. It was available, Malaj, under paragraph 3, 1/3 of the members of the legislative party, Malaj, decide to join the other. That was a defense available. We are 1/3. Right? Now, that also has gone. So there is no defense of saying, I am in majority. Your Lordship is now taking a hard fact situation that the Chief Minister has lost confidence. Actually, he's only 50 people are, out of 50, 40 are on the other side. I assume that against myself.
Right?
Right? Now, Malas, they are still subject to disqualification. So what? That's why, Malas, I said these majorities can't be decided in the legislature. What they'll have to do is go to the party,